Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have with us Josh Dossey, one of our wonderful lawyers. Welcome, Josh.
Good morning, Melinda. How are you?
Great. I'm so glad you're here.
I'm glad I'm here too.
We're going to talk today about how to get ready for a hearing.
Yes, which is probably something every litigant will do.
Right? So the litigants need to know, and if lawyers are listening, it might be a good primer for, hey, reminder.
Absolutely. There's going to be a little best practice for both of them.
Yes. So how do you start when you're getting ready?
My starting point is always asking, what is the goal? If your goal is, say, for example, we're doing temporary orders. Temporary orders are so broad. You can ask for anything from child issues to property issues. Well, the first question the client should be asking themselves and the lawyer should be asking the client is, what do you want?
It sounds so obvious, doesn't it? But if you don't do that in a way that is clear, right? You're communicating clearly, then you could have an unhappy client later because they thought, oh, I thought we were going to go ask for full custody.
Absolutely. And, that might even be something they can get at this hearing. Mm-hmm. So that's also another thing you need to do because one very big tenet of hearings is notice. You have to know, and the court has to know why you're there. Mm-hmm. So anyone who's not preparing or asking that question, you're really doing a disservice to everyone, including the courts involved. So
how do you make it clear and have good communication? Like, what form are you putting in? What are we seeking?
My favorite practice is to have a conversation. Mm-hmm. I love a phone call, a Zoom call, or even in person. So that way, if there are unrealistic expectations or if there's any confusion, that I can squash it right then and there. Mm-hmm. But to always follow that communication with an email. Say, hey, we just talked about points 1, 2, and 3, mm-hmm. and that way there's really no confusion going forward. I also turn in those wants into requested reliefs, and the client sees that requested relief prior to me preparing an exhibit, prior to me looking at witnesses. I just need to know what the client is aiming for so I can figure out how to get them there.
And the requested relief becomes an exhibit, right, that we give the court?
Sometimes. Some courts accept it as an exhibit, some don't. Mm-hmm. So I think it's always great to offer it. And if not, make it some type of checkbox. Give mm-hmm. the judge the paint by numbers so that they can easily follow your case. It also helps you easily follow your case, mm-hmm. right? If I'm getting into the thick of witness cross or witness direct and somehow I've forgotten to say, oh, and by the way, child support. It's a great way for me to redirect back to the points that I need to make that day.
Yes, so it's basically a checklist or a bullet point list of, hey, here's the 7 things we're trying to achieve this hearing. We're asking you to order judge. And what's nice about that is it lets the client look at that in advance. So if maybe you thought you were clear and they thought you were clear, but you weren't. And then I realized that the hard way when I send them that relief list. But a lot of judges, when we hear them speak at seminars, they say, we want that. We want a requested relief. They don't want to be sitting there listening to witnesses testify, not knowing what's the point of the testimony. What are we trying to get? So as funny as that sounds, like, of course you need to know what you're asking for.
Absolutely. I would also recommend taking an order.
Yes.
Even if your order is some type of checklist, think compel hearings. Judges love that. Mm-hmm. Judges love being able to specifically identify what the request is and actually make a ruling.
I agree. I love a proposed order, having a proposed order. Again, now you've taken the bullet point list and put all the language that's going to end up in an order, and your client gets to review it because they might think when it says standard possession on the checklist, they might not know what standard possession means. We know what it means. The judge knows what it means. We've explained it to them. But when they see it all spelled out in that proposed order, again, you're not going to have a client later who says, wait a minute, I didn't know that standard possession meant summer, blah, 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 right? So I think that's a good suggestion. Okay, so now we have our proposed order, our requesting relief, checklist. Now what do we do to get ready?
So the next thing I always do to get ready is I briefly go through my head my good facts, bad facts, and I start writing them down. If there's a counterpoint to my good fact or a counterpoint to my bad fact, I like to write it down. And then I like to figure out what I need to address first. Oftentimes when you're going to a hearing, you're either the movant, the person actually set the hearing, or you're responding to it, or it's competing, in which case one of you is going to go first. And at that time, you need to decide, well, I'm going to call my client and I'm going to call their client, but I need to get certain stuff out with my client and I need to get certain stuff out with their client. So what comes first? And I start putting that order in my head. I'm not very strict and we don't write a script. I think some of the best lawyers are very responsive. They're listening and engaged in the hearing. So following a script will really throw you off. Instead, write kind of big block points, a couple of exhibits that support your points, and then be ready to listen and respond.
I love that advice. So I like to start kind of with a script, at least of my direct, because I can control my direct. But you definitely, to your point, need to be able to react to what's happening live. And a judge might, at the very beginning of your case, say, I don't want to hear about X. And then you're like, well, that's the first 3 pages of my script.
Absolutely.
You have to be able to say, okay, scratch that, adjust live, or that's going to be a really irritated judge. Now, there might be times where you have to do it anyway to make a record. That aside, there's things that happen live that you need to be able to adjust to 100%. And you can tell lawyers who can't do it because no matter what just happened, they're going... But that's my third question. I'm going to ask it. So I agree. And I like what you said about you have to think about how are you going to get your evidence on? It's all about evidence, right? The judge cannot rule on something if it didn't have evidence. And evidence takes what forms?
Evidence takes so many forms. The most common form is testimony. So exactly what your client's going to say on the stand. And in that sense, you need to prepare your client to answer your questions. Many clients have this idea, justifiably so, that they need to get their story out right then, right there, and that's not always the direction we're going. Us as attorneys have to give those people the opportunity to speak and to tell what's going on in their lives because it's important, it matters. But we have to be the directors of that. We have to say these facts, these stories come out at the right time, such that the court is going to lean in your favor. And so as the topic of hearing prep, I'm going to say definitely prepare your client to listen to what you're asking and then just answer what you're asking. Don't answer any other questions yet. We will get you there.
Some people are better at that than others, right?
For sure. And it comes down to nerves. Think about people who go and appear court for the first time. They're like, I've never been under oath. I've never made testimony to a reporter, a judge, to someone who's adverse to me inherently, meaning opposing counsel, to a party that's suing me or that I'm suing. It's just a very new situation for, I would say, 99% of the population. So preparing them as a witness, because again, testimony is your biggest form of evidence, is essential in your hearing prep. And as long as you and your client can develop a relationship such that you're direct on them as a conversation, not a interrogation, then you're gonna be okay.
So do you practice with them?
Lightly, almost as much as I practiced for appearing on this podcast. It needs to be natural, in my opinion. So practice to the extent you get comfortable with each other. Prepare them with the bad questions. One example I have is in prove-ups. Some judges ask about family violence, some do not. And when I've asked a client about a prove-up question relating to family violence, they immediately seize up. Those words are just triggering and they panic. If I give them a heads up, hey, the judge may ask about this, then they are a lot more likely to be calm and just get through the question.
Yeah, I think your point is well made that most people have never testified before. They're not going to be comfortable in the environment. So you have to prepare them enough and practice with them enough that they get over that hump of just, what is this going to be like? And even though you want it to be conversational, to your point, there are rules about how it has to happen. We can't talk over each other, for example. So when I prep my clients, I always tell them, look, there's a court reporter. They can only take down one person's testimony or one person speaking at a time. So we can't speak over each other. In natural conversation, we all crosstalk, Not allowed to do that in court. And that type of preparation helps, doesn't it?
Oh, for sure. And then one of the big things I will give to lawyers, prepare your clients for objections, because they could be mid-answer, they could have not answered yet. If they hear the word objection, just tell them to pause. Because I've never seen a judge get more upset than when a witness keeps talking through an objection, continuously so. A couple of mistakes, judges are, water off a duck's back. But if they keep doing it, I've seen judges admonish witnesses.
Yeah, it's irritating for everybody. So I tell my clients, okay, if someone objects, you just stop talking, right? And then if they say objection overruled, then you get to keep talking. If they say sustained, you're not going to get to answer that. We'll move on to the next question. But they kind of get confused about that, right? They're nervous in the moment. Which thing when do I talk again? So I just tell them, look, you can just sit there. Someone will tell you, you may answer, or they'll just ask you another question. So you don't really have to sort out if you're supposed to talk again.
Oh, I have to tell you a secret. I tell my clients to not answer anything after the word objection.
Yeah.
Because I look at it, if it is overruled, as a small opportunity for me to just slightly rephrase the question to get the answer I want. It's a little devious sometimes, but it works for that client.
Yeah. Well, and that is something that people need to be aware of is lawyers, we are practiced at this and we're trying to get something into evidence. And so sometimes they really need to listen to how the lawyer phrased the question, especially in cross-examination. Cross-examination means I'm questioning the person on the other side, not my client, right?
Correct.
So they need to be aware that sometimes a lawyer will ask one question and then they'll ask a follow-up question that isn't quite the same, and it could feel a little tricky, right? They have to really listen to what they're being asked. If someone's nervous about a fact, right, they don't want to be asked, sometimes they'll just blurt out that answer because they're so nervous about, they're going to ask me this.
They do.
And they could have just listened and maybe never had to say it.
I think that comes down to part of hearing prep as well. Early on, before the hearing, start your communications in a very consistent way, such that you don't have the client, sliding you notes every other question, because it's a little distracting, right? You're trying to focus while giving your client the attention they deserve and need. Whereas if you develop the communication skills early on, you develop that trust that, oh, Josh is going to lead me there, Melinda's going to lead me there, or you're on cross, you're questioning, their spouse or the other parent, whatever the case may be, that you're going to get that bad fact out of them somehow. You might not be doing it in an aggressive way like they see on TV, like you see on Suits, but you're gonna get it out. And I appreciate the reminder, but you have to trust me, and I have to build that trust with you.
I always tell the client, don't whisper to me because the judge isn't going to like that, and I have to be listening to what's happening. But here's a piece of paper, here's a notepad and a pen, and you can write me a note. But if I ignore the note, I'm ignoring it on purpose. You don't need to keep pointing to the note. The judge is watching, right? They're watching that interaction. If that client looks crazy, that's not good for their case.
Oh, yeah, that's another thing. Your client is way less likely to react to something if you prepare them. So if you have part of hearing prep, I think I've skipped over this, is exhibits. That's the next set of evidence. You have every capability to give your exhibits to your own client before the hearing.
I would recommend.
I absolutely agree. I've seen attorneys hand their client a 4-inch binder full of exhibits the morning of walking into a temporary orders hearing. And I didn't have time to review all that. how can your client, even if it's their own material, that's just intimidating.
Yes.
So definitely send all your exhibits, have them prepared to your client beforehand. And I think it helps both you and the client if your exhibits are blocked in some type of way. Obviously, the beginning is going to be your requested relief. Depending on the issue, it's going to be everything the court requires to meet your burden kind of early on. But when you're getting into other stuff, or there's just cumulative evidence that's not directly on point, like a pay stub, instead it's, communications, emails, or texting, pictures, anything of that sort that kind of builds a narrative and isn't explicitly a fact. That kind of stuff, you can kind of work them together, right? If you're telling a story of alienation, for example, we'll make those exhibits 5, 6, 7. Don't make them 5, 23, and 46. It just throws you off, and it throws your client off, especially when they have to flip through this giant binder trying to find an exhibit, and you're like, page 2, tab 2. No, just next tab, please.
Yes. Sometimes you have to, because you're adjusting, like we talked about, you have to jump around, but at least plan to be organized. I think one reason that lawyers sometimes do not have the client prepared and they haven't reviewed the exhibits is they're just waiting till the last minute. They did it last night at midnight, right? So prepare ahead. I'm a prepare aheader, as you know. I've never understood the last minute because you just have to shift your last minute. Right? Make your last minute a week ahead so you have time to publish it to your client. Your client might have an adjustment. They might say, oh no, I don't think that's a good example of that. This is a better example. They don't have any time to do that if you wait till you're walking in the courtroom.
Absolutely. And we're speaking in the ideal. Like right now, this is the ideal client that gets you all this information a couple weeks before at least, so you have plenty of time to go through it.
And your hearing's a couple of weeks
And your
ahead.
hearing's always, and everyone's agreed to it. You're not noticing people 3 days before.
Right.
That's the ideal client, the ideal situation. Yes. Sometimes there are attorneys, through no fault of their own, preparing at midnight the night before because their client got them that information.
Yes.
And in that respect, that responsibility needs to be on the client.
Yes.
It's very easy to forget. It's not my case. It's not your case.
Yeah.
We are simply your representation. This is the client's case. And the client is going to participate as much or as little as they want. So in that regard, I think setting expectations very early on of I'm going to do as well of this case as you allow me is very important, especially for some of the clients that might be getting stuff last minute.
Right.
And a hearing is a great way to get that out of the way. A first initial hearing, learning how your client operates, learning that, oh, this person, even though I sent them this a couple weeks ago, is responding 2 days before. Okay, I need to make a point to give them like a cutoff date. And it could be an arbitrary cutoff date. I could fake it. But at least that way I'm reacting to my client's style of responsiveness and hopefully mitigating any last minute preparation that might need to happen for the next hearing. Because I will say cases usually have one hearing, like temporary orders, and then they'll settle or mediate or go to final trial, which tends to be more of the pattern I've seen in Collin County, whereas other clients will have one hearing, and that really incites 4 more or 5 more.
Yeah.
It tends to be one or the other.
They've started the fight. Some of our counties limit the time. So you brought up Collin County, 20 minutes per side for temporary hearing. Almost all judges limit your time for final trial. It would be more than 20 minutes usually. But how do you manage when you're going to have a time restraint? Like 20 minutes is not a lot of time for a temporary hearing.
Absolutely. So that's honestly a great question. And it goes back to my point of preparing your exhibits early such that you are meeting your burden first. The burden for child support is a clear financial showing through pay stubs, taxes, some type of income showing. The burden for any type of conservatorship or position and access is always best interest, or in certain cases, safety and welfare. Knowing your burden is exactly what needs to happen early on so that you can get those exhibits that best support it. Then you can get into, what mom did 2 years ago at Thanksgiving dinner, and it just kind of turned everyone off, right?
Yeah.
There are great facts, there are good facts, there are irrelevant facts, but that are important to your client to tell the narrative, and then there are, facts that you just can completely get rid of.
Yes. I like to do, when I'm time restricted, a summary. So you can do a summary of testimony. Example, let's say that it's a custody fight and my client has concerns about what's happening at the other parent's house. Well, I could make a list of those concerns. It helps my client because sometimes they lose the most important concern because they're nervous, and their most important concern is that that person is hitting the child or that that person is abusing a substance, and it makes them not really capable of caring for the child. And then without doing that little summary ahead of time, which I'm going to use as a tool, as a exhibit in the case to help my client, and to then the judge can take it with them later and see, oh, this is everything they testified about. I've had cases where if I didn't do that, the client comes in and I'm like, so what are you concerned about? They're like, well, they're not feeding them healthy enough. And I'm thinking to myself, no, you're worried that they're a drunk beating up your child, remember?
Oh, I've definitely seen that.
And then you're like, well, how do I get them to say that? So when it's short, when the time is short and you don't have time to spend 30 minutes talking about how they're eating, or that they didn't send back the right clothes that they sent them on during their possession, you got to get to the heart of the matter, to your point. What's the most serious issue? So summaries are a help. And you could also do that for voluminous records, right?
Absolutely. And that comes in a lot for communications. Most people talk a lot to each other, or now text, or
yes.
I'm a big fan of Our Family Wizard or App Close or any other parenting facilitation app, just because they're one-stop shops. But anything like that, you're going to print out 200 pages of communications that you might need one text from that.
Right.
And so, yeah, I definitely agree. Give your clients summaries, and even name the summaries. This is a summary of why I'm concerned.
Oh,
this
yes.
is a summary of why I should have the house. This is a summary of, and a little title can go a long way.
Agreed. So can you play a audio tape or a video? Is that acceptable evidence in some circumstances?
It is, if you have the right predicate. So you can't play audio that you got from your grandmother's neighbor's friend. That tends to be a few degrees of separation that the court's not going to accept. But if it's audio or video that you've recorded, absolutely it can come in, as long as it's relevant and not overly prejudicial in general. And I actually copy those audio or visual files onto a flash drive. I provide those full files to the court and to opposing counsel, of course, but I cut them down. I don't need a 20-minute video or audio of your camera or microphone sliding around in your pocket, and then there's a minute of action. That almost makes me think of like the movie Avatar. There's a lot of music. Beautiful movie, but a lot of music. Instead, just cut it down to the parts that the judge cares about, or whomever the fact finder may be, if it's final trial and you have a jury. But usually it's a judge.
So if you only have 20 minutes, you can't be messing around with your video, like you said, for 20 minutes. You need to be able to be ready to put it on very quickly. Is it legal in Texas to tape record someone if they don't know they're being tape recorded?
It is. Texas is a one-party consent state. So as long as you yourself are doing the video and you yourself have consented to the recording, yes, you can. And that's a double-edged sword, because that also means the other party could do it to you.
One thing that's been funny to me in my career is people will bring in these videos and they'll be like, look how he or she's behaving. And the video actually illustrates how horrible my own client is behaving. So be careful what you video.
Absolutely. And I mean, the first choice that clients make is who to marry, who to have a child with, who to engage in any type of relationship with, period. And so to the extent of them coming to us or the even opposing party coming to us making claims about our clients, you guys started this.
Right. We did not ask you to marry each other and have a baby.
Exactly. I was like, I didn't know you 4 years ago.
This was not an act of God.
But I'm happy to help you now.
Yes, for sure. But it can be super powerful. I've had cases where if somebody just says, oh, he or she is raging all the time and it's bad for the child, that's different than hearing someone on an audio tape truly enraged. And that can be very powerful evidence, and you don't need to play very much of it for everybody to get the picture.
Absolutely. And I think that's kind of where we can talk about witnesses a little bit. Many hearings are he said, she said, one party against the other party. And, everyone, including attorneys and judges, we take it with a grain of salt, right? People are going to exaggerate. They're going to frame things in the best possible light for their story. Instead, what you can do is add witnesses to be this kind of third-party support, something that may be a little disbelievable if I say it, but this third party who really has no interest in the matter says it, or even better, this third party who's an expert of some kind, a counselor, a therapist, a teacher, a police officer, any type of third party that really doesn't have a stake in the case can go a long way in validating your story.
That's better than your mother testifying, right?
Absolutely better than a parent or sibling or worse, paramour testifying.
Because your mother loves you and she's going to see things your way. Yeah, the third parties who are more neutral by nature are excellent. And I think courts really like to hear from them.
I agree, especially if it's short, succinct. They're not weighing in on things they shouldn't weigh in on, but rather they're just telling the facts. And again, if we're talking about hearing prep, prepare those witnesses too. You need to get a subpoena to them. Don't send it to them at the last minute. Reach out to them, make sure they're available for the hearing date. And there are such things as friendly subpoenas,
yes,
which many, many people are willing to accept without the dramatic, you've been served.
Yes. And you have to be cautious in your preparation because it's not attorney-client privilege if they're just, the child's counselor or something like that. But they just want to know, as the third-party witness, what are you going to ask me? And so I like to talk to them ahead of time or even send them a list of something that I wouldn't care if the other side saw. I'm going to ask you, how long have you seen the child? How many times? Do you have concerns if mom or dad's parenting? Are you hearing anything scary? That kind of thing. And then sometimes if they'll talk to you, they can even tell you, don't ask me, blah, blah, blah.
Yeah. And that's the best thing about third parties, right? They may or may not be on your side,
right.
But they are going to tell the truth.
Yes, for sure. And so you don't also, if you're there, you didn't call the third party, you still might want to question them because, to your point, they're going to tell it all. And maybe they made some assumptions or they didn't have enough information. So it's always great to ask the third party, hey, were you aware, blah, blah, blah. Were you aware that last night mom or dad ended up drunk, passed out on the front lawn?
Absolutely.
With that fact, could that possibly change your opinion?
Yeah, and we tend to talk about third parties when it comes to child issues because that's really most common, most helpful. But third parties can actually be very helpful in property issues as well. If you are fighting over a house or someone bought a house and then deeded it, changed the deed later, a third party can go a long way into determining if that transfer of deed was a gift, if it was some type of marital situation that, people changing circumstances. Third parties can really help in pretty much every issue, in my opinion.
Yes, agreed. So we've talked about physical evidence like a bank statement or a tax return. If you create the document or if your client creates the document, does it always come in? Does just any piece of paper we want to put in come in?
No, not always. It can, if it's supported directly by the underlying evidence, usually can come in. If it is created in such a way that it embellishes your evidence or, changes a fact slightly, it's objectionable. And that really comes down to the court you're in. I've seen judges be very, very stickler with the rules of evidence, be very, very stickler with what they're allowing to come in. And I've seen judges that just want all the facts.
Yeah,
they
just let it all in.
Yeah, tell your story and give me the big picture so I can really figure out what to do in the situation.
Yeah, and then they can weigh the evidence based on their own opinions. Yeah, some things seem more reliable. A bank statement from the bank, it's probably real.
Oh, especially if it's blurry, as we get all the time, because I know you didn't create that one. But yes, anything from a financial institution is going to be way more credible to how much you have in your checking account than you telling me, oh, $4.
Right. Oh, Josh, thank you for being here. We're going to put on the screen how to reach you in case people want to reach out. But I think this was a good, quick tutorial on how to get ready. And like so many things, prepare, right?
Yes, thank you for having me.
You're welcome. Thank you for watching the Melinda Eitzen Show. And hopefully you'll be more prepared for your next hearing, whether you're a lawyer, a third party being asked to testify, or a client. And if you feel like your lawyer isn't doing these things, assert yourself. They are working for you. So go ask them, hey, I want to meet with you in advance. When can we do that? Don't just show up and be nervous. Make them get prepared. You have a right to your choice of counsel. So if they're not doing the right job for you, you can hire someone else. Thanks for watching.